I'd like to welcome everybody to this panel discussion on the 13th Amendment and civil rights celebrating 150 years. In case you don't know, I'm Professor Darrell Miller. I see many of my students here in the audience. I teach civil procedure and civil rights litigation here at Duke University Law School, as well as having an academic interest and a scholarly interest in two amendments usually not thought of as being related, which is the 13th Amendment and the Second Amendment. I'm very happy that I've got two distinguished scholars that have come to join us in this panel discussion about the 13th Amendment. Our first speaker is Laura Edwards. She is the Peabody Family Professor of History over at the college, Duke University. She has her PhD from the University of North Carolina at Chapel Hill and has just completed a book called A Legal History of the Civil War and Reconstruction, A Nation of Rights, which just came out of Cambridge University Press in March of this year. She has been awarded fellowships with the Newberry Library, the National Humanities Center, and the Guggenheim Foundation. And if that wasn't enough, she's also been awarded the Howard D. Johnson Award for Distinguished Undergraduate Teaching and Excellence in Graduate Mentoring. The second speaker that we have is somebody that I know and have been on many other panels with, is George Rutherglen, who is the John Barbie Minor Distinguished Professor of Law at the University of Virginia School of Law. He joined the law school after clerking for Justices William Douglas and John Paul Stevens at the Supreme Court of the United States. George writes very widely and broadly on issues of civil rights, employment discrimination, and civil litigation. His book, Civil Rights in the Shadow of Slavery, The Constitution, Common Law, and the Civil Rights Act of 1866, was published by the Oxford University Press in 2013, and he's also the author of Employment Discrimination Law, Visions of Equality in Theory and Doctrine by Foundation Press. Laura is going to speak first, Professor Edwards is going to speak first, then Professor Rutherglen. I'm going to back cleanup here. Our plan is to talk about 15 minutes or so, each of us, after my short introductory remarks, and then open up the floor to Q&A. So if you're from my generation, which isn't really all that old, you grew up learning that Abraham Lincoln freed the slaves with the Emancipation Proclamation. And without doubt, the folkways of history, the cult of the great emancipator still has and commands many, many adherents. But for those of you whose memory of elementary school and maybe middle school and high school is not quite as distant as mine, you would know that the Emancipation Proclamation did not actually end slavery in the United States. The Emancipation Proclamation only ended slavery in those states in active rebellion and only as a wartime remedy subject to the president's war powers. If you were held as a slave in Kentucky, you were as much property in the eyes of the law before the Emancipation Proclamation, after the Emancipation Proclamation as before. It was the 13th Amendment, which was ratified on December 6, 1865, 150 years ago, that ended slavery as a formal, legally recognized institution in the United States, and it did it with an incredible economy of words. We've got two sections. The first says, neither slavery nor involuntary servitude, except as a punishment for crime wherever the parties shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And then we have a section 2, Congress shall have power to enforce this article by appropriate legislation. This was immediate emancipation without the piecemeal hand-wringing about just compensation that had so concerned certain gradualist camps. And at one moment, 4 million people, perhaps 1/8 of the American population, who previously could not own property, in one fell swoop did. They owned property, they owned themselves. An entire way of understanding our relationship to property and to each other was revolutionized by this amendment. And yet, as my panelists know, the 13th Amendment does not feature largely in most law courses. Probably those of you that are second or third years might have read 2 or 3 cases in your con law classes. It certainly hasn't been the wellspring of jurisprudence or congressional legislation in the same way that the Commerce Clause or the 14th Amendment has been. Hopefully, as part of our discussion today, we'll sort out the reasons why that would be so and talk a little bit about what the 13th Amendment means for the future. And with that, I'll turn it over to Professor Edwards, who, by the way, I'm sorry, has to leave a little bit early. You're going to leave right on time. Okay, all right, there.
Hey, it's really odd, I noticed, to be up here and watch everybody eat burritos all at the same time. It's kind of a scene. Anyway, it's funny. And what I want to do here is take you back to the 19th century. And I'm going to bring together 2 bodies of literature here, scholarship in the law, with scholarship in history. And I think that both of these provide a productive way of really understanding 2 things. One is the importance of the 13th Amendment in legal terms. And the other is the importance of the way that ordinary people in America can really push, and in this instance really did push, profound legal change. So as a scholar enmeshed in both of these fields, history and law, I am always struck by the assumption that underlies so much of the historical literature, that there is a straight line between individual efforts to end slavery or to achieve freedom and then the legal abolition of slavery. And this just runs through all the historical literature. Somehow, if enough people claim freedom, then slavery's gone somehow magically, right, in the law. And yet, from the perspective of legal scholarship, it is really clear that the abolition of slavery required structural change in the nation's laws, which made the leap from individual claims to legal abolition much, much less certain than the scholarship in history suggests. So individual slaves, just for instance, and obviously could obtain freedom and had been obtaining freedom for a very long time without actually changing the legal order that sanctioned slavery. Those are 2 separate things. Nor is emancipation solely a matter of mobilizing the political will of the nation's lawmakers. To be sure, the politics of emancipation in the mid-19th century were formidable, involving a delicate balance among seemingly irreconcilable concerns. You've got the differing views on slavery among the American people, all of the American people. You have federal power, the nation's war goals, as well as the immediate needs of military officials during the Civil War. But the nation's political leaders could do nothing about slavery until they confronted a legal structure that at that time gave the federal government very little power over the legal status of individuals. That power resided with states and localities. In fact, the only way the nation's lawmakers could end slavery throughout the entire United States was ultimately through a change to the U.S. Constitution. And this is something I think we kind of take for granted. Oh, yeah, the Constitutional Amendment. But they couldn't do it any other way, and that is really significant to understand. And when they changed the U.S. Constitution, they also made changes that affected all Americans ultimately, even though we tend to think of the 13th Amendment as simply ending slavery and therefore only applying to those people who had been enslaved. So that the U.S. Constitution was amended also underscores, I think, this complicated process of legal change, particularly here the importance of enslaved African Americans whose refusal to actually act as slaves not only made it impossible for federal officials to ignore slavery, but also forced them to confront slavery's place in the legal order. So in order for that to happen, in order for the nation's lawmakers to fundamentally change the legal order, they needed pushing, and that pushing came from enslaved people. So we're going to start there. Well, the first enslaved people abandoned their plantations at the start of the war. They set this motion, this legal motion and process. They didn't intend to, but this is what they ultimately did. And the iconic story of General Benjamin Butler's experience at Fortress Monroe captures the essential elements of the dynamic and the intractability of the legal issues surrounding slavery. So in May 1861, 3 enslaved men, according to the documents here, delivered themselves up. I love that passive, it works really well. They delivered themselves up to Butler's picket guards. So it's like, okay, what do we do now? We've got 3 enslaved people delivering themselves up to the picket guards. The Fugitive Slave Act mandated that all runaways had to be returned. And Abraham Lincoln, at this point, still insisted that nothing would be done to interfere with slavery. This is 1865. Especially in the states, or interfere with slavery in the states where it already existed. So the war is out, they have the war, we have 2 armies mobilizing, but the policy on slavery, according to Lincoln and the federal government, not going to change here. Current law and Republican policy statements, however, did not really anticipate the situation that Butler faced, which was 3 African-American men who sought shelter with U.S. troops because they did not want to work for the Confederate commander to whom they were enslaved. Butler saw an opportunity here. He needed labor, and so he put the men to work. Shall the Confederates, Butler asked rhetorically in one of his missives to his commander, be allowed use of this property against the United States, and we not be allowed its use in aid of the United States? So he's explaining this, and then he says, puts the issue in legal terms, ultimately, defining African Americans then as contraband, property seized as a consequence of war. And finally, he asked his superiors for instruction, even though he'd already sort of moved along this path. And his superiors ultimately wrote back to him and said they found much to praise and nothing to condemn in what he was doing. So Butler then continues to bring in enslaved people. Now, it's interesting here that he looked to the law to justify his actions, because the law actually provided authority here, at least in theory, that his orders alone could not. So he's covering his bases. He has ethical arguments here. He has practical arguments. But ultimately, he feels like he needs the law here, too. So he marshals that on his side. And here he can't turn to federal law, which allowed for slavery in states where it already existed. So he's strung there. He can't do anything with federal law, nor could he hope for a different interpretation of existing law, given Lincoln's position on slavery. So he found a way out of the conundrum by invoking international law. Lawyers are so good at finding a way out of conundrums. And international law allowed for the seizure and use of enemy property, and therefore, theoretically, enslaved people. If slaves were appropriated as contraband, then Butler and other military commanders could act without contradicting federal policy that forbid interference in slavery. They're contraband, not enslaved people. Yet the principle of contraband of war was meant only to apply to property seized from neutral parties who were shipping war material to the enemy. And there are really no neutral parties here at Fortress Monroe, unless you say that African Americans were defined as both the neutral parties, right, the shipping vessels, and their labor was the war material. So they're the shipping vessels carrying the labor, the war material. It's really inventive, but it's kind of a stretch here. Now, Butler knew he was applying this concept of contraband loosely, but he believed it was the only way to resolve the dilemma posed by enslaved people who were seeking refuge at Fortress Monroe. The truth is, Butler wrote of contraband later in his 1892 memoir, as a lawyer, I was never very proud of it. But as an executive officer, I was very much comforted with it as a means of doing my duty. Now, it did not take long for the actions of enslaved African Americans to upset the legal fiction of contraband. Since I wrote in my last dispatch, Butler informed his general 3 days after the initial letter about the 3 refugees, the question in regard to slave property is becoming one of very serious magnitude. Enslaved men were being forced to work on Confederate fortifications, and there were rumors that enslaved women and children would be shipped out of the area. And Fortress Monroe's in Virginia, so Virginia is shipped out of the area. Enslaved men are being impressed into duty. Families with children were now asking for shelter at Fortress Monroe, not just individual men, which made it impossible for Butler to continue to maintain that he was holding slaves as contraband of war, with the idea that their labor was the property confiscated here, right? So if you have little children, you're saying, oh no, labor's the issue. The 2-year-old's really not doing labor for you, so it tends to fall apart at that point. So Butler recognized what refugees were: families, not property. And he shifts. As he explained, I have therefore determined to employ, as I do very profitably, the able-bodied persons in the party, the family, as I can do very profitably, issuing food, proper food for the support of all of them, and charging against their services the expense of care and sustenance of the non-laborers, keeping a strict and accurate account, he's a good military official, as well as the services of expenditure determined by a board of survey hereafter to be detailed. So he's keeping all the accounts. He's treating African-American men as household heads who support their families. He's made a shift here. Butler knew that he was on increasingly shaky legal ground, though, so he justified his actions in strategic terms increasingly. If the African Americans in his charge were still enslaved, he informed his general, they would be worth somewhere in the neighborhood of $60,000, which represented a significant loss for the Confederacy. Without their labor, moreover, Confederate forces could not have constructed fortifications as quickly as they had. But Butler, in all of this justification, still could not hide the fact that his handling of the situation involved more than considerations about the strategic value of slavery in the war effort. And that was clear in questions that he posed to his general at one point. And here's quoting here. As a political question and a question of humanity, can I receive the services of a father and a mother and not take the children? Of the humanitarian aspect, I have no doubt. Of the political one, I have no right to judge. As Butler saw it here, mothers, fathers, children could not actually be dealt with either as slaves or as contraband, despite what the law said. And those were the only two legal categories available to him, and one he had kind of manufactured out of thin air himself. The African Americans who sought shelter at Fortress Monroe were actually shaping Butler's decisions. Butler did not support slavery, but neither was he an abolitionist, at least not at the outset of the Civil War. In 1860, he was a Democrat sympathetic to states' rights, who had voted for Stephen Douglas, not Abraham Lincoln. And by states' rights, he was very committed to leaving these questions about the status of individuals with the states. Now, previously, when in command of Maryland, he had assured that state's governor that he would not interfere in slavery and even offered to put down any servile insurrections, as he put it, there. And the Civil War, though, then gave African Americans an opportunity to change Butler's mind by exploiting the fundamental legal contradiction of slavery. People were actually not the same as other forms of inanimate property, which made it extremely difficult to apply property law to them, right? It was because African Americans were, in fact, human beings with feelings and desires and the capacity for rational decision-making that they kept coming to union lines. It's because they're not property that they keep doing this, right? So it's really hard to, keep forcing them back into that legal category. Butler and other military commanders found it impossible to ignore their actions, if only because laws premised on the assumption that people could be governed in the same way as inanimate property always kind of tended to fall apart in practice. So African Americans' actions ultimately forced questions about their status out of the military's hands and into those of the nation's lawmakers. And I'm lingering more on Butler here because I really want people to see how slaves are pushing this. They're making this an issue that is impossible really to ignore. Even people who want to ignore it now can't. So ultimately then, military commanders, they're dealing with this, and then it moves slowly into the hands of the nation's lawmakers. When Congress finally took up the issue late in 1861, they ran into the same problem that military commanders had. It was difficult to deal with the situation of individual African Americans without dealing with the place of slavery in the American legal system, and then ultimately confronting the larger constitutional questions about the basic structure of law in American society. Now, to say that the federal policy inched toward emancipation, one small step at a time, this is the metaphor often used to talk about the way that federal policy evolves, it really does not capture what's going on, and it tends to actually misconstrue the depth and the breadth of the legal issues here and the difficulties of eradicating slavery from the nation's legal structure. You can't just inch along and then kind of wave a magic wand and have slavery disappear. Now, the scholarship often focuses too on the moral and ethical dimensions of the problem, charting lawmakers' course in grappling with their own feelings. Oh, it's terrible. What do I do? And then their own efforts to persuade others to act. I've come to see the light. You should too. And then this sort of assumes that abolition can be accomplished once the tide of public opinion turns against it. But the law made it really difficult for even the most principled official, the most dedicated, the most evangelical against slavery to use federal power to end it. Federal power ultimately, too, was the only way to eradicate slavery everywhere in the nation as a whole. So federal policy actually reflects the legal constraints as clearly as it did federal officials' convictions about abolition. So all these people are trying to abolish slavery, and they keep running up against the law, which always is getting in their way here. Legislation first focused in on areas where the federal government did have clear jurisdiction, low-hanging fruit here. We can use federal power, but we can only use federal power in certain places, right? And that's the District of Columbia, where a lot of early legislation was focused, the territories, where federal policy had a clearer mandate than in states, and conquered parts of the Confederacy, where they imposed martial law, which also gave the federal government increased authority. Policies, though, tended to rely on war powers, this sort of notion of temporary execution and expansion of federal authority. And the Emancipation Proclamation, which you've already referenced, defined abolition as necessary to the war, and thus limited. This is about what we need to accomplish to win the war. What happens after? We're not quite so sure about that. It also offered freedom to some, and it had distinct limits, which you've already suggested. It applied only to enslaved people in the Confederacy, and that meant they had to leave for areas occupied by federal forces because, the Confederacy doesn't actually recognize federal law. That's kind of the point of the conflict here. And then huge swaths of the Confederacy that were already occupied by Union troops, including the entire state of Tennessee, were excluded. So this is a very narrow sort of Emancipation Proclamation. And emancipation in these terms, then, was not the same thing as the legal end of slavery. Emancipation Proclamation does not lead somehow inevitably to the 13th Amendment. They're two legally distinct moves. And slavery then still lingers here in the nation's laws at both the federal and the state levels. Now, in some way, though, the Emancipation Proclamation did nothing more than legitimize what enslaved African Americans had been doing since the 1860s, or 1860, which is, leaving the Confederacy, going to federal jurisdictions where they have a greater hope to claim their freedom, federal jurisdictions recognizing that to a certain extent. But it does more. It goes beyond that. It escalates the terms of the conflict, moving beyond the battlefield to make war on the Confederacy's social order. So when the actions of African Americans get written into federal policy, that becomes part of the larger war effort. And at that point, the federal government, the United States, is actually saying, no, we're making war on slavery here. And that is significant and a recognition that, should be underscored. But again, Emancipation Proclamation does not legally abolish slavery. It did what other federal legislation did, acknowledging the freedom of certain individuals while leaving the institution of slavery legally in place, right? And those are two separate things. The limitations of the Emancipation Proclamation and of federal policy then reflect divisions among lawmakers and white Americans, not among African Americans who are pretty much on board with the idea that we need to eliminate slavery here. There was no consensus, though, amongst all those other folks about the future of slavery in the United States. But those same limitations also underscore the power of escaped slaves' actions, which forced both federal lawmakers and white Americans to confront an issue that many did not want to confront, wanted to sweep it under the rug, wanted to make it go away without actually having to confront and deal with this in a more systematic manner. Now, slavery would remain legal in the United States until the ratification of the 13th Amendment. after the end of the Civil War. So it happens afterwards, which we should all sort of be aware of too. It takes the end of the war and then another debate to end slavery. Despite all the legal efforts to dismantle slavery during the war, it was actually impossible to do without a constitutional amendment. At some points, Lincoln had hoped that states would all abolish slavery. People had suggested doing it through statute, but states can abolish it and then bring it back. Statutes can be repealed. The only thing that gave it security was a constitutional amendment. And then even so, the dynamics culminating in the passage of the 13th Amendment were simultaneously definitive and ambiguous. They were definitive in the sense that there was a growing consensus in support of the amendment. And in that sense, we get a sense of how much had changed as a result of the Civil War, and that's not inconsiderable. Yet ambiguities remained. When the amendment moved from Congress to the states, it was subjected to considerable debate, and considerable probably understates that situation. The debate was particularly acrimonious in states of the Old Northwest, which had the most racially restrictive laws. Iowa didn't pass the 13th Amendment until after it had already been ratified. And I always find that odd. It's like, Iowa? I thought they had abolitionists in Iowa. Iowa, you waited this long? Anyway, it did, bless their hearts. And the approval process also ran into difficulties in other states where the Democratic Party had a significant presence, including New Jersey and New York, which were not all fully behind the whole 13th Amendment idea. The states of the former Confederacy were all but required to pass it as part of President Andrew Johnson's Reconstruction plan. Even then, political leaders in those states debated the amendment in their constitutional conventions as if they still had a choice in the matter. Well, should we do this? Should we not? It's like, really, folks? I think that boat sailed, but they still debated this whole thing. Now, the difficulties of ratification here then reflected larger divisions over the meaning of the 13th Amendment. So the meaning is unstable from the outset. Those conflicts are embedded into the meaning of the 13th Amendment. And I think that reflects the difficulties of abolishing slavery more generally. Republican leaders who supported abolition and racial equality saw it as an ends to both abolition and racial equality. They thought the 13th Amendment would establish racial equality. Once you eliminate slavery, then everybody would be equal in terms of civil and political rights. Some Republicans envisioned also civil and political rights as a set of principles under the purview of the federal government. So we had a national standard for those things, not standards that varied state by state. And therefore, all of these rights would extend universally to all people, regardless of their location or habitation in the United States. Democrats and more moderate Republicans objected to that. They supported abolition, but not equality for African Americans, and certainly not a national vision of rights. And many Republicans supported an expansive role for the federal government in the states of the former Confederacy on a temporary basis, and then, the withdrawal of federal authority once those states had been reconstructed, but not a permanent change in the relationship between states and the federal government. So in this sense, passage of the 13th Amendment ended slavery only to expose the extent of slavery's influence in the social order, as well as the nation's legal order. All of these questions, what are rights, who has control over them, what is the relationship of the states to the federal government, what are the relationships of American citizens to the federal government, those are all opened up by the 13th Amendment and captured in its ratification. And it also suggests here that slavery, which created a particular sort of balance between federal and state power and was the basis of creating, at least in some ways, that balance, was very entwined in the nation's governing structures at a really basic fundamental level. And it was going to be impossible to legally abolish slavery without addressing a whole host of questions, actually, about the status of all Americans. What rights could free people claim? And what was their relationship to local, state, federal governments? And what was the relationship of those local and state governments to the federal government? All of that differed in terms of people's individuals' rights, not just by state, but even by locality. So only the federal government could really address this patchwork of state, local laws that placed African Americans into different legal status than other white Americans, and that also differentiated white Americans from each other. And before the federal government could act, the nation's lawmakers had to alter the balance of power to give it more authority over the legal status of individuals. The 13th Amendment established that precedent by reaching over the states, essentially, to create direct legal ties between the federal government and the people on the key issue of slavery. The federal government, after the 13th Amendment, protected people's rights insofar as it prohibited states from keeping people enslaved. In so doing, the amendment extended the federal government's authority, though, over all states in the Union, not just those of the former Confederacy, and over all Americans, not just those who had once been enslaved.
So it's a great privilege for me to be here. I'd like to thank Darrell Miller, Sarah Holzapfel, and Zach Newkirk for arranging my stay here. It's particularly really a moving experience because we are within 3 weeks of the 150th anniversary of the ratification of the 13th Amendment. My own view is that the 13th Amendment has been neglected because of a certain focus that legal scholarship takes, namely upon judicial decisions interpreting constitutional text. There are relatively few of those decisions interpreting Section 1 of the 13th Amendment. And just looking at those decisions, there are 100 in all in the Supreme Court that cite the 13th Amendment, about a dozen of any consequence. You could conclude that it is at the periphery of constitutional development in this country. But I think that is a very short-sighted view. The 13th Amendment is at the foundation of civil rights. And I would like to offer you briefly, in the short time I will speak, a genealogy of civil rights that makes the 13th Amendment the foundation for all of the civil rights that we now have. Indeed, legislation under the 13th Amendment first defines civil rights in the sense in which we now appreciate it as rights to equal participation in public life. Before the 13th Amendment, civil rights simply meant the rights of citizens. As Laura has said, the 13th Amendment raised many questions. It freed the slaves, but then it left their status as citizens, aliens, or some intermediate category completely undetermined. And it was that Congress had to address in the legislation that it immediately passed after the Civil War. The most important of these statutes is the Civil Rights Act of 1866, which begins by declaring that all persons subject to the jurisdiction of the United States are citizens, and then identifies a range of civil rights to sue, be parties, give evidence, to make and enforce contracts, to hold, convey, sell, inherit real estate, to be subject to the equal protection of the laws. All of those provisions tried to elevate the former slaves to the status of equal citizens. And indeed, the Civil Rights Act of 1866 made this quite clear. It said that all citizens have the same civil rights as is enjoyed by white citizens. It tried to raise everyone up to the standard of full citizenship that was appreciated at the time. Now, from the Civil Rights Act of 1866, it is very easy in the documentary record to proceed directly to the 14th Amendment, which is widely studied, really the source of many of our rights to equality. But Section 1 of that amendment is based directly on the Civil Rights Act of 1866. In fact, they proceed in parallel fashion. First, to define who is a citizen of the United States. Secondly, to protect the privileges and immunities of citizenship. And third, to provide for due process and equal protection. And this is no accident. There were questions raised about the constitutionality of the Civil Rights Act of 1866, whether it exceeded the powers of Congress to enforce the 13th Amendment. And at the same time, the Committee on Reconstruction convened in Congress and considered various versions of the 14th Amendment. All of them are based on the Civil Rights Act of 1866. But because in law schools we look at the influence of judicial decisions and the prevalence of constitutional provisions as cited in those judicial decisions, we have lost sight of the fact that the 13th Amendment led to the Civil Rights Act of 1866, which in turn led to the 14th Amendment, and then soon thereafter to the 15th Amendment, conferring the right to vote without regard to race. This is the claim that I insist upon, that if you want to understand civil rights, if you want to understand the many tensions that Laura identified in her talk today, you have to start with the 13th Amendment and with the legislation implementing it. It led in short order to all of the Reconstruction Civil Rights Acts that we are familiar with, in particular the General Federal Civil Rights Statute, today known as Section 1983, that is directly modeled on a provision in the Civil Rights Act of 1866. Now, that story, I think, is compelling, and it shows that emancipation had to lead to consideration of the question of legal status. And that question might have been answered differently. We don't know. We do know that it was answered emphatically immediately after the amendment took effect by the same Congress that passed the 14th Amendment and sent it to the states. What is remarkable, in my opinion, is that this foundational act has reverberated to the law of civil rights as it developed in the 20th century. So that in 1866, we dealt with a newly minted concept of civil rights, equal participation in public life, without much of a conception of exactly what equal participation was, without much of a conception of how wide public life would be. The Civil Rights Act of 1866 started to answer those questions. Subsequent Reconstruction legislation went further. The 15th Amendment identified the right to vote as essential to participation in public life. But then, at the end of Reconstruction, this radical purpose of achieving equality fell into eclipse in decisions like the civil rights cases, Plessy against Ferguson. And it was only revived gradually in the middle of the 20th century in what eventually became the civil rights era. And it's worth just pausing for a moment and seeing what the development of these rights were as they came to fruition in Brown against Board of Education and then became effectively enforced. Brown stands for the proposition that all people are entitled to equal education, regardless of race, in state-sponsored schools. Brown against Board of Education does not disturb the state action limitation upon the scope of the 14th Amendment. It was, in that respect, somewhat limited. But if we just focus on judicial decisions, we see that the scope of the 14th Amendment is mired in deep-seated doctrinal controversies. If we look at legislation, we see a very different story. So that just as the Civil Rights Act of 1866 followed the 13th Amendment, the great civil rights acts of the 20th century followed Brown against Board of Education. The Civil Rights Act of 1964, which finally succeeded in prohibiting racial discrimination in public accommodations, hotels, trains, places of entertainment, even if they were privately operated. The amendment also created a broad prohibition against employment discrimination, with the novel addition of a prohibition against discrimination on the basis of sex, in addition to a prohibition on discrimination on the basis of race and national origin. The Voting Rights Act of 1965 finally settled upon an effective mechanism for protecting participation in the political process. The Fair Housing Act of 1968 tried to address problems of racial discrimination in residences and the ownership of real estate. At just this moment, the Civil Rights Act of 1866 was revived. It was revived to address our newly conceived view of the breadth of public life in this country, not limited by the state action doctrine, but extending to the central institutions of our market economy, the central institutions of our political process. That extension and interpretation of the 1866 Act was controversial. I will not repeat the controversy for your benefit. But in 1991, Congress said that was the right thing to do. And so if we look at the broad span of civil rights legislation in this country, we see that the very first Civil Rights Act, passed immediately after the Civil War, had a profound influence on the very last major piece of civil rights legislation passed in 1991. I think there's no better testament to the enduring influence of the 13th Amendment and to the work of the Reconstruction Congress than its long-lasting influence that proceeds over more than a century. I find it particularly distressing when the Supreme Court limits the power of Congress, as it did in Shelby County, to address the problems of enforcing civil rights laws. But I think a look, not necessarily a triumphalist look, but a look about the enduring influence of Reconstruction legislation can give us a more hopeful picture. And I impress upon you the interest and the excitement of looking to this history and the appeal, as President Lincoln said, to the better angels of our nature. Thank you very much.
All right, so like I said, I'm going to back clean up, and I'm going to keep my remarks very short so that we have a little time for question and answer. So for many years, I've been toying with this essay or article, or I'm not sure what to call it, called A Meditation on the 13th Amendment and Constitutional Redemption. So the idea of constitutional redemption is not new to me. That's something that Jack Balkin has actually written an entire book on. But I think it has some purchase when we speak to the 13th Amendment, as I'll discuss. The remarks were spurred by a conversation that I overheard at a conference at the University of Chicago in 2008. I think George might have actually been there as well. And an observation. So the observation was this. The 13th Amendment is the first and only time that the word slavery is used in the Constitution of the United States. This is so interesting as a textual matter. You have this norm that is pervasive in the United States. It's a flashpoint of such controversy, and yet the word never appears in the Constitution until the Constitution purports to abandon it. Now the conversation. I overheard two scholars at this Chicago event who were complaining about the fact that there were no representatives at the School of Divinity, and they began to cite portions of the congressional record and the history about how so much of the emancipation movement was driven by Christian doctrine, the evils of slavery, the need to cleanse the body politic of what most people sort of refer to as the original sin of the United States, what Garrison famously called a covenant with death and an agreement with hell. So just a disclaimer, I'm not a Catholic. And so I am going to talk a little bit about the 13th Amendment in light of the Catholic the doctrine of reconciliation. But those of you that know your catechism better than me can come up and sort of correct me on this. It's always struck me that the elements of the Sacrament of Reconciliation can speak to the structure of the 13th Amendment. So the 13th Amendment, again, says, neither slavery nor involuntary servitude, except as a punishment for crime, wherever the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. And then Section 2, Congress shall have power to enforce this article by appropriate legislation. So the elements of the Sacrament of Reconciliation are confession, contrition, penance, and reconciliation. So there we have in the Constitution the confession. We can now say it, slavery, that is the sin. I think it's an important moment in constitutional history, right, to recognize that there's this spirit that has been in the Constitution but not named, and to name it. It was a norm, a constitutional norm in some sense, without a constitutional or textual hook. And so the first point of the Sacrament of Reconciliation is confession, and so we have here in the textual sense a confession. But confession is not enough, right? The second element is contrition. A person must be sorry and must be contrite. And to be contrite, you have to know what you're sorry for. Not every utterance of the word slavery in our history really means slavery, right? The framers are incredibly profligate with the term. Everything's slavery, right? My tea's being taxed, I'm a slave, right? The creditors in England, want their money paid. It's just like slavery. I really seriously doubt that Thomas Jefferson thought he was going to be put in the fields with Sally Hemings, right, if they lost the Revolutionary War. So no matter how much the way slavery as a custom of law was used, right, not how it was used in every single rhetorical flight can be the meaning of what slavery is. So what does slavery mean? Well, I think this is a place to visit the actual text. You'll notice that the text uses two terms, slavery and involuntary servitude. Both are forbidden, except for the crime exception. The truly penitent people know what they've done, and I think it's important to think of slavery not as simply a synonym with involuntary servitude, but as encompassing an institution, a set of relationships about power, about domination in America, especially with regard to race. It's about who should be considered in making decisions and whose considerations don't count. It's about family organization. It's about religious worship. It's about education. It's about all these things. We lose sight of the word slavery if we fail to understand what the word conjured up in 1865, both to the people who wrote the Abolition Amendment and also those people that were the primary beneficiaries of it. But as Peter de Vries has said, confession without penance is like a tweed coat is to dandruff, palliative but not remedial. It is a form of what Dietrich Bonhoeffer once called cheap grace, the preaching of forgiveness without the requiring of repentance. So penitence, as Thomas Aquinas once said, had two aspects. There was the pena vindicativa, the sort of restoration of the moral universe, and the second was the pena medicinalis, the medicine that prevents further sin. So how is the 13th Amendment penitential in this way? Well, in the first instance, as Gara Binder has said, the vindictive part, the restoration of the moral universe, is that the 13th Amendment is the Constitution not because of the intricacies of the Article 5 process, but because of the scourging of the Civil War. In fact, that terminology comes up in how Lincoln describes the meaning of the 13th Amendment. But what about the medicine that prevents future sin? And that's where I think 13th Amendment Section 2 enforcement power comes in. That's the powerful medicine. It is the method by which the 13th Amendment performs penance for the sin of slavery. And so in cases like Jones versus Alfred H. Mayer, which George had mentioned, the 13th Amendment doesn't require state action. It's a very powerful medicine. The Congress has power to rationally determine what are the badges and incidents of slavery and legislate against its return. So what about the last stop, reconciliation? When is this process done? When are we all saved? And I'm not sure that we are, and I'd like to finish with a quote from James Baldwin, who said, quote, "There is never a time in the future in which we will work out our salvation. The challenge is in the moment. The time is always now." And I think there is a strong urge amongst the Supreme Court to say slavery is over, racism over, Reconstruction's over. The congressional activity in this area is no longer required. There's a strong desire from the court to say all of us are now saved. And my point is that if that kind of reconciliation is to come at all, it's not to come from a pronouncement of 5 justices of the Supreme Court, but must come from ourselves. Thanks.
Looking at the time period between 1865 and 1868, from the ratification of the 13th Amendment to the ratification of the 14th Amendment, what was the status of the Dred Scott case as ruling case law? Was it still valid? Had it been overturned by mere legislation, the 1866 Act? Or was Dred Scott still intact until the first section of the 14th Amendment was ratified?
I think formally it has to await ratification of the 14th Amendment. The 1866 Act purported to counteract Dred Scott, and that was one of the doubts about its constitutionality, which, led the 39th Congress basically to try to entrench the protection in the 1866 Act into the 14th Amendment. I think Laura mentioned the desirability of constitutionalizing these protections because legislation might subsequently be repealed. So that.
Well, and yeah, Dred Scott's always really tricky anyway because it actually conflicts with a lot of the ways that states are handling questions of citizenship, and so it was kind of murky from the outset. And in 1863, I think it is, Lincoln actually asked his Attorney General to come up with a statement about, do we actually know what a U.S. citizen is? And the Attorney General says, no, it's not defined anywhere. So Dred Scott comes in to define some people out of the category of citizenship in a legal context where we don't actually know what citizenship is. And so this question of citizenship for all Americans really is crucial and at the heart of these Reconstruction amendments. And it's very clear to lawmakers that we don't actually know what a white citizen is, let alone what constitutes basic categories, who is admitted to citizenship, do you need a little paper, what is up with that exactly? So it's very clear that that's ambiguous. It's ambiguous. Republican Party leaders know that. And so Dred Scott sort of exists in this netherworld where, in fact, the categories aren't particularly clear, and they don't become clear until the 14th Amendment, although they're trying to resolve them also with the Civil Rights Act.
I should just add, Dred Scott itself is a disaster area. I mean, it's impossible to read it and even find out, you know, who's in the majority for which proposition. But
Other questions?
Referred to sort of categorically stated that Black people were citizens, right? And so could you all address perhaps the effort on the part of Blacks to use the passport as recognition of their citizenship prior to Dred Scott and after Dred Scott?
Yeah, actually, Martha Jones is doing great work on this,
Yeah.
right? Where African Americans, free Blacks in particular, were always very, from the time of the Revolution, were very concerned about their status in relationship to both states and the United States, because it was not clear that they were going to be accepted as belonging as part of either the nation or the states. And so they are very active in using various means to establish that kind of connection, and passports are one way, right? Because if you're a free Black, you leave the state, and many free Blacks are sailors, so they're often leaving the state or the nation. Can they get back in? And so the issuance of passports becomes a way of establishing claims on the state and on the nation, and establishing claims of citizenship. And free Blacks are also doing this in various other ways through claims in civil courts to like church property, through the possession of guns, through the ability to file all kinds of cases that then establish a direct connection between the courts at the state and the federal level. Movement also functions within the United States, right? So a lot of the freedom of movement of free Blacks, a lot of the questions of freedom suits are involved mobility. So it's that issue of mobility when you move from one jurisdiction to the next that raises questions of belonging, and those become crucial cases. And that's where you get this really murky thing with Dred Scott, because states have very different ways of handling this and recognize different degrees of belonging on the part of free Blacks. I'm sort of avoiding citizenship because sometimes they avoided that term. And so, you know, Dred Scott drops into this world where it has been contested since the Revolution, and many states and localities and even the federal government do recognize a connection between free Blacks and these states. So it's not like it wasn't there and then all of a sudden Dred Scott, you know, affirmed that, but it has been contested all the way through, and largely because of the actions of African Americans.
And if I could just, I mean, it's important to point out, like I mean, there's cases in which Black people that are walking around or trying to enter into contracts or to do something by the skin color are presumed to be slaves, right? That's the default presumption, and it has to be overcome by some, you know, affirmative act on the part of the person to show that, I mean, this is the how the norm is distributed among the society, right? Black people, you will assume, will be slaves unless there's something else to show that they're not, and this would be one of those ways of you know, of sort of disproving what was a sort of baseline assumption. Other questions? Neil?
This is, in my judgment, an uncommonly thoughtful panel, and there's so many questions one could ask each of you. I'll just stick with one briefly to George. I mean, might one way of interpreting what you said, might you be laying the groundwork for a synthetic interpretation of different amendments, right? Interpreting one in light of others, given the genealogy and the connections between them. So, for example, might be one way of understanding Shelley versus Kramer, not the way it's conventionally understood, which is as implausibly saying that there's state action, but rather in light of the connection between the 13th and the 14th Amendments with respect to race, because race is special in this country, state action is not required.
You could do it that way. Shelley against Kramer actually had a companion case that referred to the Civil Rights Act of 1866, which seemingly would have handled the case without any appeal to the Constitution. So the way I would look at the mediating impulse, and this draws on some of the work you've done, is that the enforcement powers of Congress under various constitutional provisions tend to overlap and merge, and it's very awkward when there are little gaps between them. I mean, you see this in the Affordable Care Act case where, people, try to say, well, the Affordable Care Act somehow doesn't fall within the Commerce Clause, it somehow doesn't fall within the taxing power, somehow doesn't fall within the spending power. But I think there's a powerful urge to look at all the powers of Congress together, and that they can be invoked, and routinely are, in order to achieve what is regarded as necessary goals at the time. So I would see the mediating influence as legislation under the powers that Congress has.
We're done. Well, with that, I'll have to thank our panel, and thank you for coming out.